Good evening, everybody. Thank you for joining us for another edition of Family Matters with Judge Phil Smith. We appreciate you joining us tonight for our topic on child support and alimony. So we've got a lot of good information to share with you. I want to say a special hello to Judge Amanda McClendon. As an elected official out there, we see that you are joining us this evening. Judge McClendon, thank you for being here. You want to turn on your video and say hi to everybody?
There we go. Do you hear me now?
We hear you. We don't see you.
Oh, sorry about that. I don't know. There's much to see. I'm on day 2 of a jury trial. I'm afraid I'm going to lose you.
Oh,
Well, Judge McClendon, I have to just say one thing about that. Better you than me.
Well, I'm working on the jury conference, so I'm still not the charge conference. It's been 2 days and it's been contentious. And I've got to say, I admire you all for what you do in our domestic courts. It's such an essential part. So thank you for allowing me to attend in recognition.
Sure. Anytime we do this, we do it once a month and it's fun.
Well, I tell you, I'm looking forward to the happy hour. I want my free drink.
There you go. There you go. Well,
okay.
All right. Well,
I'll sign up now. Thank you.
Thank you, Judge McClendon. And I'll just, kind of roll off of what she said. Is there a happy hour announcement that you want to make, Judge?
Well, I'm working with Carla Hewitt to try to get back the domestic relations happy hour. I have not heard from Carla, but I think she's working on it, quite frankly. So I'm hoping in June, maybe the second week, we'll have cocktails like we used to, and excited about that. But no, let me mention, I am working right now on putting together a CLE seminar on domestic violence. We've had a lot of lawyers that have, or actually not a lot, but a couple of lawyers that have requested that we put together a seminar on domestic violence for domestic lawyers, red flags, so they can, maybe detect when there is domestic violence involved. We've had several deaths in Davidson County, more than I can ever remember, more gun deaths as far as DV cases than I can recall. So we want to educate the bar, the domestic bar, as to those red flags. Also, I'd like to cover some vicarious trauma for lawyers that deal with DV cases, abuse cases, or sex abuse cases. And finally, one of the components I would envision having is self-protection. And lawyers need to know what to do to keep themselves safe, particularly in this area. This is a highly charged emotional area, and people are kind of getting a little crazy these days on, domestic cases. So I think that's something that we could all benefit from. We get that kind of training at Judicial Conference, and I've really never known lawyers to really get that kind of training, but I think it's something that is really important and something that we need to do. Looking at probably the end of July or August, sometime in August for it. But I hope everyone will attend. I'm envisioning it happening in the jury assembly room at the historic courthouse. And then maybe afterwards, we can have a little happy hour across the street.
Sounds like a plan.
Yeah.
So since we were last together, we have received two things: new guidance from the CDC and a new order from the Supreme Court as it relates to COVID and mask wearing and rules for gathering and things of that nature. So can you talk a little bit about that, how that's going to apply, what your courtroom will be doing differently going forward?
Yeah, I mean, we have been down on the 5th floor, and next week I'm not having a motion docket, But beginning on June the 4th, we'll be back in the Fourth Circuit courtroom, which I think, quite frankly, is the most beautiful courtroom in either of the courthouses. I'm a little biased, but we're back in that courtroom. And we're going to continue to have staggered dockets. We're going to make a change, though, and instead of having the 9:30 docket, we're just going to have a 9 o'clock docket, and we're going to incorporate defaults along with those cases that we have traditionally heard on the 9:30 docket. You know, cases that may take 2 or 3, you know, no more than 5 minutes to dispose of. And then we're going to have a 10 o'clock docket. And those are the cases that are, you know, involve, you know, more proof, more argument, that's going to take a little more time. And, you know, if we need it in the future, we can always do an 11 o'clock or even a 12 o'clock, depending on how many motions we have. But that's going to be a slight change, of course, under the Tennessee Supreme Court guidelines. Social distancing, according to the Supreme Court, it was reduced from 6 feet to 3 feet. We will still have a limited number of people in the courtroom, and we're going to see how this works out. We will have a lot of people in the hallway. The purpose of the 5th floor was to kind of cut down on that number, but with the guidance from the Supreme Court, we're going to go ahead and try it with being back in our own courtroom. It's certainly much easier. And it's particularly when you're going across the hall to Third Circuit or down the hall to probate. So those are changes that will be taking place on June the 4th.
Okay, sounds exciting. What is your policy going to be as it relates to mask wearing?
It's up to the individual. I'm not going to require it, but you know, it's hopefully that, you know, if you've not been vaccinated, you for whatever reason you wear a mask, and but it won't be court ordered. It's just it's optional.
All right, sounds great. So I want to do a really quick check-in with you, because last time we were here, you gave us an update on your wife, who has experienced COVID and has really had some lingering symptoms. How is she doing? How's your family, generally speaking?
Well, thank you for asking. The last 2 weeks has been great for Pam. She has made just significant strides. She's off of the oxygen at this point. She still gets winded, you know, taking a few steps. But this past weekend, she went and assisted in keeping grandchildren. And as I was telling you before we started, she and I are dog sitting for our oldest daughter. We've got our dog and her 2 dogs, and believe it or not, in a lot of ways, they're more difficult than the grandchildren to keep. But she's doing much better. Good prognosis. So, but thank you for asking. I want to thank all the lawyers that have expressed concern, and she's going to be okay. She's going to be okay.
That's great. That's wonderful to hear. Thank you for sharing that information and keeping us updated. So if you don't mind, I'd love to just jump right into tonight's topic. And I'd like to start off a little bit with child support. And
Okay.
We had a case recently in court, and I want to say that they were potentially pro se litigants that were in front of you to get a divorce. And so they'd worked out their marital dissolution agreement and their parenting plan, and in there they had 0 for child support because you know, they were saying, hey, everybody does what they're supposed to do, we're not worried about this. Can you talk a little bit about child support and what it's really for, and your responsibility or obligation as a judge in ordering it?
Okay. Let me kind of, if you don't mind, I want to give a little bit of a history, and there's some lawyers on here I know that are going to remember way back in the day. I noticed Brenda Clark's on here. Brenda will remember. But back in 1988, which was a long time ago, Judge Robinson, my predecessor, was appointed to head a committee to look at child support guidelines. Back then, when I first started practicing, you might get a $25 a week child support award. And maybe, you know, the non-custodial parent is making, you know, $100,000. But it really didn't matter what the non-custodial parent was making. It really looked, you know, you looked really solely at the need of the custodial parent. And it didn't look really close. These were kind of cookie cutter awards, $25 a week, $35 a week. And even back then, those were very low amounts. So the federal government under the Title IV Act or Title IV-D Act came in and said, you know, states, you've got to put together some guidelines or you're going to lose federal funding for some of your child support programs. So Judge Robinson headed a committee and they actually looked at the income shares guidelines back in 1988. For whatever reason, the legislature did not adopt those guidelines. And they went for what the percentage guidelines that we were under for a number of years. And many of the lawyers here will remember those. The percentage guidelines, you just looked at a percentage of the income of the non-custodial parent. And, you know, in some income strata, those amounts really kind of appeared unfair. And in the higher income cases, you know, that you were getting way above what the need of the child was. So we were under those until I believe 2005 and 2006, when we had the income shares that we're under now. And they've been modified a couple of times. But now, of course, we look at the incomes of the parties to create kind of an imputed need. And the guidelines are not, I mean, we can't waive the guidelines. What we can is deviate from a strict application of the guidelines under certain circumstances. Those circumstances are limited. Child support is for the care of the child, okay? But it covers a lot of different things. You know, I've heard arguments before, well, Judge, you know, my spouse is not spending the money on the child. Well, part of that child support, you have to remember, goes to an electric bill, a mortgage, water bill, groceries, clothing. You know, it's not meant to be spent just for the child itself. You know, this is imputed in the award itself. So, you know, child support awards are not optional. The guidelines apply and we have to do it. And a lot of people don't understand why. The reason is it's the law. It's, you know, these regs are binding on the court. If I were to just disregard the guidelines and the case goes up, it's coming right back down. You know, these are not advisory, they're binding. So, you know, lay people particularly don't understand that. Well, I don't want any child support. It's really not your choice. The guidelines are binding. They are the law of the land and we have to follow them.
And so I do want to get into, and thank you for that history. I was actually myself unaware of that, quite frankly, in terms of the fact that there was just no real guidance before 1988 or at that time, and how child support was just kind of based on the need of the parent that was awarded the support. So we have definitely come a long way in terms of how we determine or how we calculate child support. My understanding of the guidelines now, as you say, is income shares. What I always like to explain to people is, you know, what that takes into account is it looks at the income of both households and it comes up with a calculation is it, you know, based on the household of the mother and the father making X amount of dollars, this is how much money should be attributed to the child. And there's an assumption that the mother is providing her portion based on her pro rata share of that income, or not the mother, but the parent that is the primary residential parent where the children or child spends the majority of the time, it's a presumption they're paying their share of it just by the virtue of the child being in their care. And so then the difference comes out of the, is attributed to the a parent that does not have the child majority of the time, or in some circumstances, just maybe, maybe more money if it's equal time or whatever the case might be. And so it really looks to keep the children or the child in a lifestyle that is conducive to the joint incomes of the parties. And so that was the biggest change that I understood from the income shares. But I do think I want to talk a little bit more about, what does child support cover? Because sometimes people will say, well, I need money for clothes, or I need money for school supplies or extracurricular activities. So, when is it appropriate for somebody to come in and ask for money outside of what is ordered in child support? What are things that are automatically considered in a child support order, and what are things that would be extraordinary expenses?
Well, let me say, extracurricular activities are covered in the child support award up to a certain amount. And then at that point, you can ask, I believe it's, I can't remember the percentage, 7 or 7.5% that they can ask for in regard to assistance on extracurricular activities. Extraordinary expenses, of course, are two different things. You've got potentially extraordinary educational expenses or extraordinary medical expenses. These are all things that can be considered to increase an award of child support. I think it's called the Basic Child Support Order. All of these things can be included as an add-on to the Basic Child Support Order. And educational expenses we see a lot, not so much on the extraordinary medical expenses, but on the educational expenses we see a lot in private schools, and whether a party is going to be responsible for all or part of private school tuition. And the test that the guidelines instructs us to apply is, could they afford private school if they were in an intact family unit? And I've seen cases where people, putting their children first, both are working parents, they're struggling, but they do have their child in private school. Now, in my opinion, in some of those cases, they couldn't afford private school, but they wanted their children to have the best education possible. So sometimes that presents a tough decision on the part of the court. In other cases, clearly they do have the ability. It may be just that one party doesn't want to pay. But if they do have the ability, or did when they were an intact family unit, then in all probability, the alternate residential parent is going to have to assume part of that responsibility, or potentially.
That's really interesting to me, because having the ability as an intact family unit, I think we could reasonably agree that an intact family unit has less expenses than two separate households, right? One household is less than two. So, that's interesting, because I would wonder if there aren't other considerations the court would have to have or consider, outside of if they could afford it as an intact family unit. Because as a single person, if you're carrying a mortgage and, or rent or all these other expenses by yourself versus splitting them, that would have an impact on your ability, I guess, to pay for private school tuition.
Yeah, I think under the guidelines, you do have to apply some common sense. And, getting back to those situations where you have two people that were struggling when they were together to have a child in private school, or children in private school, even in those situations, maybe they've made the decision, but maybe it wasn't a good financial decision. Maybe they're making car note payments late. They're behind in their electric bills, and certainly you applaud the effort and and the consideration, but it may not be, even in that situation when the children are in private school, appropriate for the court to order it. Yeah, there has to be some common sense. You look at other things too, because it certainly is cheaper for two people to live together than it is separate and apart. So you have to add an element of common sense there. There are considerations that the court's going to look at and make that decision.
So as we talked about a little while ago, we look at the income of the parties, and it's, that's pretty cut and dry, or it is really cut and dry when someone is employed by an employer and, they receive a regular paycheck and a W-2 at the end of the year. But let's talk a little bit about, because we had a few questions actually that were presented to us before tonight, to talk about how do you look at the income of a self-employed individual for purposes of determining child support?
That's something we deal with a lot. It's those are difficult decisions, but you go outside the books, so to speak. A self-employed individual, and when we see a lot, and it's unfortunate. Parents don't mean to necessarily do anything inappropriate or illegal, but a lot of people that have small businesses live out of their business account. They're paying their mortgage out of the business account. They're paying car notes out of the business account. They're buying groceries out of the business account. And, it makes it difficult, not only from an accounting standpoint, but it makes it really difficult to determine what the actual income is. And so you have to look at that. And probably the best way to determine what the actual income is if they've got a separate checking account. One, if they're paying stuff out of the business account, the things that are clearly not related to the business, mortgage payment, electric bill, water bill, cable bill, telephone, cell bills, unless it's related to work. Those things you just pull back out. Then you start looking at this other checking account. Look at what the money is that's flowing through that account. And, does it add up to what they're saying is their monthly or annual income, or is it more, or is it significantly less? What are they spending that money on? These are things you have to look at, and these are really difficult cases because it is all about accounting. And if somebody doesn't keep good records, unfortunately, that may hurt them in a child support case. Because, if they're living out of the business account, they're not keeping records, maybe there's a lot of cash involved, it's not going into the bank. You got to have checks and balances, and those checking account statements and credit card statements versus what they're showing on the books or coming through the business account is what you've got to look at.
Yeah, it is. It can get a little bit tricky. And then when you have some people that don't want to be as forthcoming with things, it gets a little bit more trickier.
Yeah, and you gotta remember one side, particularly if it's a contentious relationship, the side that is looking at the small business owner, they're going to suspect everything. Well, there's probably a lot of very viable business expenses, but depending on the business, I don't know what's a good, reasonable business expense for what they're doing. They have to tell me. And, looking at past years, that's another thing, look at. Don't look at just 1 year. But it involves a lot of testimony, a lot of accounting, not, formal accounting, but informal accounting, and a lot of time with a calculator and just going through things.
So let's talk a little bit about COVID and people's employment and their income. Does the court, or you in particular, take any judicial notice on maybe people's incomes that have decreased during COVID? And how do you consider that? If you were setting support today and we were looking at last year's numbers and this year's numbers aren't as solid yet, kind of what do you take into account?
Well, you have to take COVID into account. It's for real. It has affected our economy. There were businesses shut down, for almost a year. We're coming back. The service industry, restaurants and, staff and bartending staff, all of these people have been hurting. They've been hurting. So yes, you have to take it into account. Again, you have to look at COVID cases like that on a case-by-case basis. There are really no cookie cutter rules on it. And I have actually, I don't like to modify support once it's set pendente lite. I want to get to final hearing, but we've had to modify. We've had to go back. We've had to make those adjustments. And you have to look at it just on a case-by-case basis. And, how much money have they lost? Do they have any other opportunities? What is the unemployment they're getting if there is such a thing that they're entitled to? There's a lot of things you look at. And while that ability to pay is affected, there's no question it is and has been. The needs of the child or children, they don't change. They don't go down. You have to consider that too. Is someone who is making good money before COVID, during COVID, have they been unable to get a comparable paying job? Have they taken a job, just to have income? And I know a lot of people have done that. And then you've got folks that, that are just underemployed. And, you have to look at that too. So it is a really complicated consideration for the court. We have to be cognizant of the fact that it's something that that we're going to have to deal with over at least the next year.
Mm-hmm. Yeah. Also, we've had some questions and calls about how do we handle these situations. I hope I'm correct in saying this. If I'm not, I certainly welcome being corrected. But I believe that the government will start sending out some type of additional assistance or checks to parents or individuals, a certain amount per year, but broken down into monthly payments, like of $300 a month starting in July, I believe is what I have read. And so how, I'm sure we'll get these calls. We've already had them about stimulus payments. And, how will the court address that in terms of how those funds should be allocated, or, and in two cases, because one case you'll have some cases you'll have a final order, right? And so you'll already establish maybe who gets tax credits and things of that nature, and that might be a little bit easier to ascertain or deal with. But then when you're in the midst of a divorce and you got a pending case, how does the court look at that?
Yeah, I think probably we're going to have to look at, the intent of the guidelines and, is this going to be income within the meaning of the guidelines for calculation or attribution to the party who either to the party who's receiving it. I think it'll be a short-term kind of fix that we have to provide, because I think the Department of Human Services is already looking at this, and, under their promulgation authority, they have the ability to modify the guidelines to include it as income or not. So I think what we do as judges in the interim is just going to be a short-term fix. quite frankly, I don't have an answer to that right now. I don't know. What little I know about it, it seems to me that that would be considered income. Now, there again, I could be wrong. I have not really followed this, but that's something I will be having to look at. I'm sure we'll be getting a lot of the judges will have something on this at conference, at the June conference, and they'll provide us guidance for this kind of short period of time until the Department of Human Services promulgates something. But we're dealing with this with stimulus money, how to divide stimulus money, and it's just a whole new world out there. It's amazing what is coming out of COVID. And I was talking earlier today on the MBA program that I was on. The practice of domestic law is going to go through, in the words of Bill Haltman, a paradigm shift post-pandemic. We went through one in 2008. We're going to go through another one. And there are just so many unanswered questions. We're going to have vaccine issues. We're going to have issues regarding tax credits, issues, on this situation, and I don't even know what to call it. And we're going to continue to have issues on stimulus money.
Mm-hmm. Yeah, I would agree with that for sure. Time just flies when you're having fun, and I'm having a ball. And we're kind of at the 6:30 mark, and I want to apologize and say this because I really was prepared to shift to alimony about halfway through, but I still have some questions about child support that I want to go through. So we may end up having a part 2 of this session, if we aren't unable to cover alimony the way we want to. But we got some more questions in. One is about we had a few questions come in about setting retroactive support. I'm assuming that's really setting support back to the date of separation is when we have that happen. Or some people will consider retroactive support if a support order is in place. Let's say there are 3 children, 1 child has emancipated, and then you're going back, setting it on the remaining 2 children sometime after that first child has emancipated. What does the court look at when going back and setting support backdated to a date in the past? If 2 years have passed, how do you calculate that income or that support? What do you consider in calculating the support that should have taken place during that period of time?
Well, and we're talking about what I refer to as true retroactive support, a period of time the parties were separated prior to getting a pendente lite order of support. You've won. I think you have to look at, has there been any support voluntarily paid during that period? And I think the payor should get credit for that amount. A lot of times, quite frankly, most of the time, it's very little money, if any, that is paid. So, that retroactive award a lot of times can be easy if you just look at the incomes of the parties and run it back, say for 2 years, run it back 24 months, okay, assuming they've had the same employment. Now, where retroactive support gets a little more difficult is where it is for a longer period, 10 years. Wow. Jobs, people have changed jobs. They're not making, they were making a lot less money back then. So it gets really, really complicated. And most of these cases involve Will Talent. And Will does a really good job on these. He will go back and look at their incomes for each year or every 2 years, and we'll have figures for each year that we go back retroactive. Now, in regard to the issue of if there is a child that emancipates and the modification, remember, just the child emancipating is not enough to trigger a modification, maybe a review, but not a modification. There still has to be that 15% significant variance. And so, we have to look at it from the standpoint of, okay, if that variance is there, then, and maybe that child emancipated 2 years ago, we kind of look at the same things. Has there been an income change? And if so, how much? Or do we just go back to, and we can't go back past the filing date of the petition per se, but you have to look at that income. And if there is not a 15% significant variance, it doesn't get modified, even though this one child is out there and emancipated.
Yeah. Thank you for that. Another child support question or area in child support that I want to talk about is underemployment. So there are obviously times people will come in and say, Your Honor, he or she could make more money and they're not. And so I don't want to set child support off of the amount of money they're making. They have the ability to do and earn more. Can you talk a little bit about how the court looks at being underemployed or voluntarily underemployed and what the court does in those scenarios?
Yeah, I mean, you look at when you look at past employment, that's where we start. And I remember a few years ago, I had a case, Thayer versus Thayer. I think it's a reported case now, where the husband, ex-husband, the father of the child, was making pretty good money as a mortgage broker. And then 2008 hit, and his income went down, but he was still making pretty good money. Well, he said, okay, I'm in this for the long term, and I'm just going to go with this other company, get in on the ground floor. So, in a few years, I can make really big bucks. But as a result of that, going with this other company, he took a substantial reduction in income. And I remember looking at that case and, thinking, well, he's probably thinking about it the right way, but this is not going to be a good result. The reason is it was a voluntary decision on his part to take this lower paying job. And the Court of Appeals affirmed it, but you have to remember when you are the payor, when you've got the financial responsibility, if you are going to take a lower income paying job, you have these other responsibilities that it could affect. And, a modification in child support is not automatic. So, you're looking at, in that situation, he was voluntarily unemployed. He purposely, voluntarily took a lower paying job, knowing he had this obligation. Don't fault him for, wanting to build for the future. But right now, his priority should be his child support. Mm-hmm. And, we see this a lot. We see people changing occupations. This is what I've done for all these years, but this is what I want to do. That's great. But if it's going to result in a lower paying position, then you're going to be very possibly deemed underemployed. So, but if it's a voluntary decision, now if you're laid off and there's not many jobs in the area that you have, worked many years in, or you're qualified for, and you have to take a lower paying job, that's an involuntary act. And so that's not voluntary unemployment. It depends on the facts of the case. But if you're working far below what your educational level dictates, then you're probably voluntarily underemployed.
So I have a question that was posed that's a little bit of a different scenario where the person wants to have a perspective on being voluntarily underemployed or unemployed of a remarried spouse. So the question is, In a child support modification case, would the court consider it a reasonable choice of a mother being voluntarily unemployed if the mother, who is now remarried, is choosing to stay at home to care for young children that she now has with her new spouse? In other words, if the payor of child support was married to a woman who worked during their marriage and they had children, and then subsequently that same lady has now remarried and has new children from her new relationship, and is choosing to be a stay-at-home mother, would the court impute the amount of income that she was either making at the time of the divorce or that she is capable of making based on her history?
Well, obviously, I can't speak to what I would do in a specific case.
Sure.
My thought is on that, if the children or the child or children are not special needs, then probably am going to impute some income based on the previous employment of the spouse. Remember, that was a voluntary decision to get remarried and to have children. Certainly, it is very laudable for a mother or a father, a parent, to stay at home with young children. But this is a voluntary decision on the part of that parent to that may affect her, in this case, her ability to pay support. So yeah, I think that's probably a voluntary unemployment situation. And two, if the court doesn't do that, does that not increase the obligation of the obligor parent?
Yeah.
And is that fair? Is that what the guidelines intended? The answer is, in that situation, no. I think if this was their plan when they were married and they're going through a divorce and one parent, the primary residential parent, is going to stay at home for a period of time with the minor child, then I think that's a situation where you don't impute income because that's certainly mentioned in the guidelines. It's something the guidelines consider. But in this subsequent relationship, isn't that a voluntary act? And that voluntary act is putting that person in the position of not having any income. Kind of the way I would look at it.
And then we have another question along those lines. If a spouse remarries post-divorce, and let's say, or former spouse remarries, and that spouse is now married to a new husband or wife, and that new spouse provides support to that person. So let's say I divorced somebody and I got remarried, and my new spouse is now providing support to me financially in the form of taking care of the household and paying bills and things of that nature. Would the court consider the support that I'm getting from my new spouse and attribute that to income for me for purposes of determining my income and calculating child support?
Well, I tell you, after what I participated in today at the National Bar Association office, and tonight I'm really getting some tough questions. How do you quantify that? I don't think, that being married is sharing responsibilities, sharing income. I don't really think, now, if there's a sum certain that your spouse gives you, and maybe it's $1,000 a month that your spouse gives you just to do with what you want to, that's something that's very quantifiable. And I would do that and have done that in cases. But as far as the contribution to the electric bill, the payment of the mortgage, those things are very difficult to quantify. So I don't think that was the intent of the guidelines.
So we know that child support, or we may not, everyone may not know this, child support in Tennessee is an obligation until a child emancipates. And our definition of emancipate is when they turn 18 and graduate from high school, is when a child emancipates. So, but we do have extraordinary circumstances where we have children that are disabled or severely disabled, and we have statutes that cover the ability for a parent to continue to receive child support for a child under those circumstances. I would like to talk a little bit about that. I know we've had some cases recently in our court the past couple of years that dealt with this issue. One that went up and you were affirmed on. But let's talk a little bit about what the court looks at when you're looking at considering support beyond the age of majority, and for a disabled child or severely disabled child. There are cases where sometimes the children are able to provide some support for themselves, but not fully. Talk a little bit about how the court views those cases, what you consider, what you look at when making a determination on those cases.
Well, we start by looking at the statute itself. I think it's Tennessee Code Annotated 365101H. And I remember that because I was reviewing something just within the last couple of weeks regarding special needs. I believe it's H, but yeah, there are two things that the statute tells us. One is if the child is disabled within the meaning of the ADA, the Americans with Disability Act, then child support can be required until the child reaches the age of 21. And then the other provision deals with a child who is severely disabled. And the case that I dealt with involved the question, both, which does the ADA provision apply, or is the child severely disabled? And in that case, I found that the child was severely disabled. There's a lot that, I won't say a lot, but there's a couple of cases that really provide the court with guidance, and it deals with the quality of life that a child that is deemed severely disabled is going to enjoy. And in this case, it was a young lady who was very nice, very sweet. She had graduated from high school, going through a special program. She'd actually been a cheerleader. Very bubbly personality, but she, I believe, had an IQ of around 65. She could, put stuff in the microwave and warm things up. Really didn't have a concept of money, or a very limited concept of money, in that, the difference between a $1 bill and $5 and a $10 bill versus a $100 bill really didn't understand the difference. She would have, she's had some part-time jobs, but they were provided with accommodations for her. They involved basically picking up and loading stuff and things of that nature. No cash register work, no computer work. And she actually had a little blog at one point, and where she would get on and kind of talk about, music and things of that nature. But she could not function without the assistance of her primary residential parent. She really had a difficult time getting up, understanding time, getting somewhere on time. She couldn't drive. All of these things affect the quality of life. And I don't recall the style of the case, but the Court of Appeals says this is what you look at. It's can they essentially provide a normal quality of life? And normal is not the term they use, but a normal quality of life without the assistance, the full-time assistance of a parent or guardian. And in this case, I found that she couldn't. Another thing that's interesting and unique to both of those provisions is the court has discretion as to whether to apply the guidelines or not. And in this case, I didn't apply the guidelines because while she did have a part-time job, the guidelines didn't take into account the money that she earned. And I thought that was important, and that needed to be considered by the court in fairness to the alternate residential parent that's continuing to pay this amount. So I was lucky the Court of Appeals affirmed me, and I think, I'm not sure, but I believe an application for permit, well, I can't say that. I'm thinking about another case, but I was comfortable with the decision, and I think at least while her parents are alive, she will be provided for.
I want to talk a little bit about, we've got about 10 minutes. So if anybody wants to type in questions about child support, that would be great. I've got a couple more to ask. I'm hesitant to get started on alimony because that's just a whole nother animal, and we don't have enough time to really get into it. We do have cases where people are married and sometimes they separate but don't necessarily file for divorce. And when they separate, they may go down but they may go to juvenile court and get a child support order. And then subsequently, they finally decide to file divorce. And so they're now in circuit court or our court getting the divorce. And so, but there is a open case in juvenile court with a child support order. What is it that people need to do so that they don't have two orders running? How do they need to, for lack of better words, consolidate those cases or merge them? What is the process that we require for that?
All right, consolidation is a dirty word.
It is. I knew it was the wrong word, but it was the first thing that came to my mind.
Well, Brenda Parks will, she lectures me all the time. We don't consolidate. Actually, what you do is one, and we had this problem come up maybe a year or so when I went on the bench. Obviously, if it is arising out of a dependent neglect case, then everything involving that child, if there was a finding of dependent neglect, will remain in juvenile court. Child support needs to obviously be where the child, where the orders affecting the child is. And what we're running into are these orders, and lawyers didn't know, their clients weren't telling them about it. And then, I'm setting child support, or, they're coming in with an agreed permanent parenting plan. And then the next thing you know, they're getting 2 notices from the state on, the payment of child support. Well, you look at the docket number on one, well, this is the case out of circuit court. What's this? Well, this is another case, coming from the department. And I'm not familiar with that docket number. You look into it, well, that juvenile court order was still running. And what you can have is an obligor under 2 different orders in that situation. And most obligors don't want to pay under 2 orders. And so, what we want to do is you want to go to juvenile court and terminate that proceeding down there. If there is an arrearage under that juvenile court order, get a judgment for that amount and make sure that's in the order, because I can enforce that judgment once it is reduced to judgment in circuit court. And then you want to be under the circuit court order. But just imagine how confusing it would be if I'm dealing with parenting time up here in circuit court and child support is running in juvenile court. You need the 2 of those really together. So if you have that situation, make sure to go to juvenile court. They actually have forms now, I think, that they use. And, one of them, child support magistrates will get with you, maybe set a court date, get the other side in, ascertain what the arrearage is, give the recipient parent the judgment, and, dismiss the remainder of the case with the judgment to be enforced in circuit court.
Yeah, that can get a little tricky, but absolutely. And
It
you're
can
right.
get tricky. It can
Litigants
get
don't
tricky.
always tell their lawyers, they don't even think about it half the time. Sometimes, they went to
No,
the child support office during separation and that's how that case got going. And, it just kind of
yeah,
doesn't
maybe
cross the time.
maybe they've reconciled and not even,
That's right.
about it. So
That's
yeah,
exactly right.
that comes up usually, I'd say probably 7 or 8 times a year. We have to deal with that.
So, one last thing before we wrap up tonight, I want to talk about deviations. What does the court find to be, what type of deviations does the court find to be acceptable when deviating either, well, upward or downward? I think there's probably more concern deviating downward than upward generally. But what does the court find? What types of reasons does the court find acceptable for deviations?
Well, the one I see most frequently is talked about in the guidelines, and that's travel expenses. That is a basis to deviate from the child support guidelines, strict application of the guidelines. And there's a good policy behind that. We want the relationship to continue with the child. The obligor parent may be responsible for all of the cost. And so, that parent should, certainly have consideration in the amount of the child support that they're paying because of these travel costs. And you see these mainly in relocation cases, or parties have agreed and one spouse moves away. You could have it though in an intrastate case. Say that there is an exchange of the child every weekend, and one parent lives in Crossville, one parent lives in Nashville. Well, that's gas that's being, consumed every weekend.
It's very high right now.
Yes, very high right now.
Very high. Mhm.
And it's something that the court can consider. Probably not going to be the deviation that if the parent is paying for airfare, but still, it's something that is constant. It's quantifiable, and it's something the court may consider giving a little break on deviation. Other things, we've got the hardship issue in on a first setting, of child support that we can consider. There may be on an upward deviation, maybe extraordinary medical needs, and maybe that need, and we've seen it, I've dealt with it before, where you have a parent that has to stay home with a child because the child is severely disabled, and it's going beyond what we typically see. Maybe the child is on some sort of life continuing equipment, maybe maybe on oxygen, maybe on a feeding tube, things of that nature. That is certainly a basis for an upward deviation. But you're limited by your creativity on deviations. If it seems fair to you, then you may want to give it a try. Now, please, under the guidelines, though, when you deviate, make sure you put the language in there and you explain why you're deviating, but include that strict application of the guidelines would be unjust and inappropriate, and the deviation is in the best interest of the minor child.
Mhm. And I always tell people, sometimes people are looking they're looking to get to a certain number that may be different than the calculation. And so what they will do is they'll play with the income. And I always urge people, make sure your income information is correct. Your income, your child care, your medical insurance costs, those need to be right. So, because when you come in for a modification, you need to have a baseline to base it from.
Mhm.
It's better to do those numbers right and get the basic child support obligation or the obligation from the calculator, and then see how a deviation may work. If
Mhm.
there is a good reason for a deviation, see how you can use a deviation to maybe get to a number that you're trying to get to, if it makes sense. How does the court consider deviations when it comes to modifications, right? So if there's a child support order and there's a deviation, and then somebody comes along with a modification down the line at 7 o'clock. So Joyce is going to kill me. Maybe I'll pause right there.
Why don't we continue this for next month?
We're going to continue it for next month.
Yeah.
And I will tell you this, we're going to have to come up with a plan for next month. I was looking at my calendar this week or today, and I'll be on an RV somewhere out west on the 3rd Wednesday of next month.
Well, we'll
So-
probably have to change the date next month.
We might have to see what we're going to do, but
Yeah,
thank you
we'll have to.
everybody for being here. Thank you as always, Judge Smith, for your time and your infinite wisdom and sharing it with us all. And we'll see you soon.
All right, thank all the lawyers for participating. I always enjoy this. Always enjoy this. Thank you.
Thanks. Hey, Stan. I see Stan Queller. He's in California, I think.
Oh, hey, Stan, he's watching from California. Great.
I'm sorry, I'm at a bar with my wife and my son's mother. And you remember you married my son and his wife. His mother's in town with us. We're out here in La Jolla having a drink.
Well, have one for me, or make that 2.
Yes, sir.
All right,
Good night, everyone.
good night.
Bye-bye.